All right, ladies and gentlemen, once again, my name is Kim Harrington. I am the National Sales Director with Kessler Financial Group. We are, once again, excited to have you guys on the call. We understand that this is a very, very hot topic right now, and the information that we're going to share with you is truly important for a couple of reasons. One, to eliminate any rumors that you may have heard from someone's uncle down the road or something like that, but more importantly to kind of drill down on what is truly taking place. What we see are some of the things that will be coming down the pike and how we're going to deal with them moving forward. So it's not like it just affects people in Omaha or Atlanta. It affects our entire industry, so it's really important that we're all on the same page when it comes to this. With that said, I am going to introduce you to a gentleman who is extremely sharp, and I know he doesn't want me saying this, but I'm going to say it anyway. He is extremely sharp. His name is David Rao. He is the Chief Operating Officer and General Counsel with the Annexus Group. He has 20 years' experience as a partner at Snell and Wilmer. He's represented the public and private companies with values ranging from several $1 million to Fortune 500 companies. He's recognized as one of the best lawyers in America ever since 2005. So dedicated to his community involvement includes the Thunderbirds, Arizona State Politics, and Arizona Special Olympics. So with that said, I am actually going to turn it over to David and just let you know for time purposes, if you have any questions, and some people are saying there's no sound, so let's take care of that. Okay, so there you go. If you can dial in, 267-279-9000, and the PIN number of 431738, hit the pound sign. That should work. Okay, so let's try that. And with that said, David, it's all yours, buddy.
If anybody missed that introduction, the key part was that I'm really sharp. I don't mind that. If you didn't say it, Kim, I was going to say it about myself. Thank you for having me on the call. Thank you to the Kesslers. Thank you all for jumping on. As you might guess, I've spent an appropriately inordinate amount of time over the last several months studying the proposed DOL fiduciary rule and thinking about how it will impact our business, meaning Annexus's business, our advisors, and the industry as a whole. In case anybody isn't familiar with Annexus, we are a product design and distribution company primarily operating in the fixed indexed annuity space over the last 10 years. We've got a product with Athene and a product with Nationwide, and then we just launched our first life-based product, an IUL with Minnesota Life. So what we don't touch on is VAs or any registered products, but I will get into that a little bit. I think there are a number of registered reps on the call, so I'll get into that a little bit as I go through my remarks. And I don't want to give away too much at the outset, but my overall outlook is cautiously optimistic, at least for Annexus on the FIA side and our top advisors. For this call, I want to start with a little bit of context on industry regulation and scrutiny generally. Then I'll go through the nuts and bolts of the DOL's proposed fiduciary rule, call it the highlights or the lowlights, and I'll update you a little bit on where things currently stand and potential timing, and then give you my thoughts on the potential impact. And Kim said a good thing about rumors, and rumors are rampant. I've been on several calls with advisors over the last couple months, and everybody's heard this or heard that. Interestingly, I've never practiced in Washington. I'm not a lobbyist, but I've spent a fair amount of time with folks over the last couple of months who do this for a living, and they've made uniformly the interesting comment that in general, public entities are like a sieve with information. Within 10 minutes of something being discussed in the internal meeting, it's on the streets of D.C., and that has very much not been the case with this rule. The DOL has really been bottled up tight, so there really isn't great information about where they're headed or where the rule might end up in its final form. Just a whole bunch of speculation. So I will add my own speculation to that as I go through, but I'll give you that disclaimer on the front end that it is speculation, and I'll try to make it clear when I am speculating. So let me get started. Just to put this all in context, as industries grow and mature, they become increasingly subject to scrutiny. I was a trial lawyer for 20 years, so my first thought of scrutiny is always increasing attention from plaintiffs' lawyers, and that has been happening in our industry with FIAs and with the retirement industry in general. But the phenomenon is equally true on the regulatory side, and that has also been happening in our industry, and again, including FIAs, VAs, and other retirement products. For example, the DOL has been trying to get this rule in place for almost 6 years. They had about a year-long effort back in 2010 that they abandoned, and then obviously came back in April of last year. At the same time, various states have been tightening illustration and marketing standards. The New York Attorney General launched an investigation into indexed annuity sales practices back in 2013. The SEC is supposed to come out with their own fiduciary rule later this year, et cetera, et cetera. And if you think about it, that trend is somewhat logical. As an industry grows, it impacts more people, and more people are going to be interested, and it's pretty much inevitable. And I suspect that almost everybody on this call has dealt with these types of changes at various points in their careers. The DOL rule is obviously a huge leap down that road. So let's jump into kind of what they're trying to accomplish. So it's called the DOL proposed fiduciary rule because the primary impact is the expansion of the definition of fiduciary and the expansion of the universe of advisors that will get sucked into that definition. And when I say expansion, I mean they're expanding it about as far as you could in the English language. And I've been advising people to approach the situation thinking that anything anybody says to anybody about anything to do with qualified money is going to trigger a fiduciary standard. There are some carve-outs, there are some exceptions, but they're relatively narrow right now. It may be one of the things that gets expanded, some of the carve-outs in the final rule, but as of right now, you should just assume that if you're talking to anybody about qualified money, you're going to be being held to a fiduciary standard. The biggest issue for at least our advisors at Annexus and presumably most of the people on the phone is that fiduciaries generally can't receive commissions. It's a conflict of interest. Most fiduciary rules prohibit conflicts of interest just across the board. Under the DOL rule, they call it a prohibited transaction. The good news, or at least the semi-good news, is that they provide for exemptions to prohibited transactions. So there are prohibited transaction exemptions. You'll hear them referred to as PTEs, and that's how I'll be referring to them today. There's two primary PTEs that are of interest and that will come into play. The first is called the best interest contract exemption, the BICE. You'll hear it referred to as either the BIC or more frequently, I think, as the BICE. The BICE is less of a concern right now to Annexus and our advisors because it only applies right now to registered product sales and VA sales to IRAs only. And I keep saying right now and qualifying it because there has been a relatively persistent rumor starting in about December that one possibility is that the DOL pulls FIAs from the 8424 that I'll cover in a little bit over into the BICE. The best information that I've had, and frankly my informed speculation, is that won't happen. And that the BICE will continue to apply only to sales of registered products. But we'll see here in a few weeks how that works out. The BICE is the one that's really been getting all the attention. So and there has been a lot of confusion between the BICE and the 8424 that applies to FIAs that I'll talk to in a second. But the The BICE is the main one that people are saying is unworkable, that's going to cost $20 billion for the industry to be able to comply with it, et cetera, et cetera. The highlights of the BICE and some of the big concern points are, number one, it requires a written contract between the BD, the advisor, and the client, and that written contract has to be entered into at the first meeting. And probably the best practice is going to be that you enter into that contract before you have any kind of substantive discussion at all. Obviously, that's got people concerned. The typical client is a little bit leery of coming into the meeting and the discussion with the financial advisor to start with, and now they're being presented with a pretty detailed contract before they even have.
Talking about Dan Williams or whatever.
And what you can provide in your.
Did you see that?
Et cetera. So that's problem number one. That contract lays out the fiduciary standard. It commits the advisor to complying with the fiduciary standard. It also lays out the client's rights, including a private right of action, which doesn't create. So now if there's a claim that the advisor acted inappropriately or didn't live up to the standard, it's not just a regulatory claim, it's not just a fine, but it actually gives rise to a private right of action, which also has the industry quite concerned. And part of a theme of the DOL and part of the theme of the industry's concern is that there's almost guaranteed to be an explosion of litigation, at least over the first couple of years as things sort themselves out, which generally isn't good for anybody.
I'll forward you the email.
Other highlights or lowlights of the BICE are significant ongoing disclosures to the client. So there are compensation disclosures at the front end, but there are annual disclosure requirements to the client. There's significant ongoing disclosures to the public regarding the type of business that's being done, fees that are being charged, returns, et cetera, and that's through a public-facing website. This is another one that really has the industry's attention as almost unworkable, or if it's workable, will be extremely expensive and time-consuming to comply with. There's also significant ongoing disclosures to the DOL itself. Those are annual disclosures. And there's a requirement of advance notice to the DOL of the intent to rely on the BICE fee with regard to the individual transaction. So again, this is the one that's really got the industry's attention and is the subject of probably 95 to 98% of the articles that I've been reading. And interestingly, and hopefully you all are following this at some level, but the article pace has picked up over the last month to where I see 2 or 3 articles related to the DOL every day. So it's a lot of stuff going on. There's been, as part of that, there's been a lot of recent discussion about how BDs in particular could restructure their business and their product mix to really avoid the BICE altogether. These folks, registered representatives, are already subject to fiduciary standards, so how can you operate under your existing standards and just avoid the BICE? The whole point of the BICE is that it allows you to continue to receive a commission. And so the way to do it would be to not receive commissions. So think of AUM, strictly AUM business, so a VA product that could be sold into an AUM mix or fee-based VAs. So there will be, and those products already exist. They're a very small part of VA sales, 3 or 4%, but those products and that approach could grow significantly, assuming that the BICE remains as it is, and this thing goes into effect later this year, and I'll talk about that timing in a little bit. So that's the BICE, and again, it's the best interest contract exemption. The 8424 PTE, or prohibited transaction exemption, is the one that applies to sales of fixed indexed annuities and sales of VAs to 401k plans. And 8424 is this exemption has been around since 1984. That's where that 84 comes from. It Also allows for the receipt of a commission with regard to sales of the impacted products. For our purposes, I'm focusing on the FIAs. And there's essentially, it essentially requires the advisor to comply with what it calls an impartial conduct standard. And the impartial conduct standard has three primary elements. And I'm going to take them in sort of reverse order of how they appear in the rule. The first element, for my purposes, are no misleading statements. And I take it in this order because they're easier to deal with. So no misleading statements. Hopefully for everybody on this call, that's easy. You're not making misleading statements about the products you're selling in the course of your business today. The second element is reasonable compensation. So the compensation that you receive for this transaction must be reasonable. This one's got the industry concerned because reasonable compensation is not defined. I mean, literally, that's all the rule says is that the compensation must be reasonable. This is one where a couple things are going to happen. One, compensation levels will probably go down as people try to find a comfort level, people meaning carriers and advisors that are selling those products. And the other thing that's going to happen is there's going to be litigation. So there's going to be litigation claiming that compensation is unreasonable, and eventually, as opinions come out of those cases, the industry will be able to triangulate on what courts are finding reasonable and have a comfort level, but there will be litigation, there will be expense and ugliness along the way. And then the third element of the impartial conduct standard is called best interests, and that is essentially the fiduciary standard. And I assume that that's what's caused the confusion between 8424 and the best interest contract exemption. It's the same term, and in fact, it's the same fiduciary standard. It just doesn't come along with all those other requirements of that best interest contract exemption or the BICE. So, and this is where we're going to spend some time because this is for and again, I don't know the mix of folks on the phone. I'm assuming that there's a lot of folks on the phone that are already operating at least part of their business under a fiduciary standard. A lot of our advisors are insurance license only, so they're not. So I like to spend a fair amount of time here. I'm going to start by reading the provision. It's short, and then we'll kind of break down some clauses. So the best interest standard, as part of this impartial conduct, is the advisor must exercise care, skill, prudence, and diligence under circumstances then prevailing that a prudent person would exercise based on the investment objectives, risk tolerance, financial circumstances, and needs of the buyer without regard to financial or other interests of the fiduciary or any other party. So I break that down into three elements. The first is really the standard of care that the advisor needs to exercise, and they use four words that are somewhat synonymous: care, skill, prudence, and diligence. And the way that I interpret this is you're using four words as the DOL because you're really trying to make your point. So this is again, this is similar. The words are different and the phrasing is different than other fiduciary standards, but the concept is the same. This is a high level of care, skill, prudence, and diligence. This is being at the top of your game. And as I've been making presentations to our advisors and generally they're groups of our top advisors, I mean, my point is that you're already at the top of your game. You're even though you haven't been subject to this standard in a legal way or a regulatory way, you're probably already complying with it. That's why you're good at what you do. I hope that's true for most of the folks on the phone. But again, now you're subject to both regulatory action and potentially private rights of action if you're not operating at that level. So care, skill, prudence, and diligence. The next clause for me is what I have to take into account with regard to the clients. And so, again, there's four terms: the investment objectives, the risk tolerance, the financial circumstances, and then generically the needs of the buyer. So, again, and I'll get into sort of how folks are going to comply with this. But again, you're talking about four things, and these are sort of objectively different. Investment objectives could have some overlap with risk tolerance, could have some overlap with financial circumstances, but they're really different concepts. And the needs is sort of a generic catch-all that, again, could be developed through litigation, what exactly that means. But the point here is that you're going to have to be taking extra steps to really identify where your client's at, what they need, what they want, what they can tolerate, before you can really exercise your care, skill, diligence, and prudence to recommend a product that is in their best interest. So again, the point being that you're taking your game up a notch. And then the last phrase of this is without regard to financial or other interests of the fiduciary or any other party. So the fiduciary in this is the advisor or the registered representative or any other party, which could be their agency, their BD, et cetera. So this is another one that's got the industry concerned, because if you think about it, there's an inherent conflict to this clause and the fact that I can receive a commission. The commission obviously is always going to be in my financial interest. So this is another one that's got the industry concerned and hoping for some clarification from the DOL in the final rule. And I skipped over a little bit the compensation. Within 8424, it specifically allows the receipts of what it defines as an insurance commission. So it specifically says that a commission is okay. Again, it has to be reasonable, and you have to be making your recommendation without regard to your financial interests. The definition of insurance commission, notably, is relatively narrow. It does not allow for any compensation from any party other than the carrier, which is different. So that and that would include, and it's kind of getting more to a registered rep standard. So that would include any other perks or really anything of value from any other party. So in our circumstances, that could be an IMO. It also doesn't allow for any kind of revenue sharing, any kind of administrative support from anybody. So that could be the IMO or the carrier. It's really limited to just the commission that's payable with regard to that product transaction. So I've been using an example of how this plays, or I mean, it's a very narrow, finite example, but how this could play out in the real world. And again, I'm focused primarily on FIAs because that's what we do. But if you think about, and I apologize if folks aren't familiar with FIAs, but if you think about a product with an income benefit that's a simple 7% roll-up, and you take it out 10 years, you could have an income base of, say, I'll make up numbers, of $120,000, and your contract value, or $180,000, and your contract value's only $120,000. So you've got a nice income benefit base, but you can imagine easily a circumstance where your client needs access to their money, and they've got this huge divergence between their income benefit base and their contract value base, and they see that as a negative. And you've got an alternative product that could have generated the same amount of income but had a contract base that was either the same as or much closer to the income benefit base. So could be reasons to sell either product. Maybe one has a better guarantee than the other one does, or any other number of reasons that you could think of. But the concept that your client may need access to that money, and that you could discover that need if you had taken a closer look at, remember the four terms, their financial circumstances and their needs. Maybe they've got aging parents. Maybe they've got kids that are in trouble and may need to move home, or whatever it is. Those are questions that you're going to have to ask, and those are factors that you're going to have to take into consideration under the new rule. And I'll talk a little bit more about about strategies for complying with the new rule in just a second. So I want to talk about the current status and where we're at. So the final comment deadline was back in September 24th. The DOL took the proposed rule under advisement at that point. They had over 30,000 comments to consider. They had 4 days of live testimony to consider. The next step in the process was the DOL has to send it to the Office of Management and Budget. That's a White House office. They did that at the end of January. And then the OMB, Office of Management and Budget, has a review period that's generally 60 to 90 days. So that's going to be somewhere between the end of March and end of April that rule is going to come out of the OMB. The OMB could actually deny the rule, which won't happen because Obama's one of the biggest supporters of the rule. But it'll come out, and we'll finally be able to see what changes, if any, were made to the proposed rule. The speculation is that will be coming out of OMB no later than the end of March, so there'll be an accelerated review process. And the rule right now has an 8-month implementation period, so it will be almost certainly effective by the end of 2016, which is sort of according to plan because Obama really wants it effective before he leaves office. It's very possible that certain pieces of the rule will have a longer implementation period, like this public-facing website, in response to the comments that were received. But for our purposes, the fiduciary standard, which is probably the most important piece, will almost certainly be effective by the end of 2016. There have been a number of legislative attempts to derail the rule. None of those have been successful. There's a couple more in play right now. Everything I'm hearing is that they're unlikely to be successful, and there's almost guaranteed to be litigation filed, perhaps even before the rule comes out of OMB, but almost certainly within weeks after it does come out of OMB. And they'll be seeking an injunction as sort of the centerpiece of any litigation, trying to get this thing to not go effective. Everything I'm hearing is that there's not a lot of confidence in at least the ability to get an injunction. So again, we at Annexus, and I would encourage you to plan on the rule being effective before the end of 2016. So I said I was going to be somewhat optimistic. I don't think I've demonstrated that so far in the last 20 minutes. I want to talk a little bit about the potential impact, and then I'll finish with what I see as the high notes. So the potential impact, standard of care, obviously going up. That has an impact on all sorts of things that you do, and it has an impact on the carriers. They've been using the term suitability on steroids. So they're scrambling to figure out how they review an application to determine if the best interest standard has been complied with. It'll mean increased paperwork for advisors, certainly, and it could extend as far as things like a review of alternative products. So, okay, you're recommending this product. What other products have you considered? There will be an impact on commissions. At a minimum, commissions will flatten. So you won't see a big disparity between a high commission product and a low commission product. And I think it's entirely possible that there will be at least some depression in commission levels generally. I mean, you could see 1% or 2% over the next year or two. Obviously, additional compensation I already touched on. There won't be any, or it'll be much more structured and difficult. There will be advisor E&O changes. Most E&O does not cover any kind of fiduciary liability. So for those insurance license-only folks, they're going to need to get a new rider for their E&O to make sure that they're covering that fiduciary liability. And then the last question that's really an open issue is the scope of the impact. So, keep in mind that we're only talking about qualified money. So will carriers extend these standards to all products? Will they try to have a track for qualified money and non-qual? I think the best guess is that they will extend it to all products, if not immediately, probably fairly quickly. And for a number of reasons. One, it's easier administratively for them and kind of the more conservative approach. It also sends a good message to regulators that they're taking this seriously and they're trying to be proactive, and would be a way to head off potential further regulation. So the opportunity, and again, I've been making presentations like this to our top advisors. I mean, one of the opportunities is that there are going to be advisors out there that either can't or won't or don't want to comply with these standards, and that will look for other ways to make a living or other products to sell. And obviously that just opens up potential clients. From the Annexus perspective, as the rule is set up right now, there will guaranteed be a negative impact on VAs. And as VA sales have been declining over the last 3 to 4 years anyways, as FIA sales have been picking up. But that trend should be accelerated on both sides, which we see as an opportunity for Annexus, also for advisors are experienced and comfortable with FIAs. That's a natural place for that money to go. From our perspective, and I'll try not to turn this into an Annexus sales pitch, but I think that it's going to be more problematic to sell products from lower-rated carriers when you're being held to a best interest standard, and we're very pleased with where our carriers are. From the key for the folks on the phone, and the key for Annexus, frankly, is sort of taking an educational leadership perspective. To the extent that you are not already associated with someone that you feel comfortable is sort of trying to get ahead of the curve of this, you need to think about that. We are trying to get ahead of the curve. The main thing that we're working on, and I'm spending a lot of time with the IRI, and they're working on this effort also, but the main thing we're working on is the checklist or documentation that you could use through the sales process to ask the right questions and get the answers, and then evaluate the information that you're getting from the client to get to a product recommendation that you can defend under the best interest standard. That's really going to be the key to continuing to do business. And frankly, if done right, it should help lead to sales rather than hamper. It should create confidence on the part of your client. The downside is that it's more work, that it's going to take longer. It could take multiple interviews, et cetera. And again, that's some people are not going to want to deal with that. The ones that are left are going to have more opportunity, in our opinion. And then the final, I'll do a 20-second sales pitch. Is the track record of the Annexus products is exceptional. We've far outperformed our competitors over the last 10 years. And we think that's going to be a great selling point when you're trying to establish that you're acting in the client's best interest by making a particular product recommendation. So that's all I've got. Again, I think you could almost do this same thing again in about 5 weeks when the final rule's out. I believe there will be some changes. I'm hopeful that they go in the right direction as we see it. But Kim, I think, told you how you can ask questions. I'm happy to stay on the line and answer some questions.
Okay, David, I know we have one question from Keith. It says, can this DOL law be repealed due to the presidential election? So basically, when the new president is elected, whoever that might be, can that person or the Congress or whoever make a change to it without doing what they're doing now?
Absolutely. And I would not be surprised to see that happen if the election goes the right way, i.e. a Republican. But because there has been, there's been significant distress on the part of a large number of even Democratic lawmakers about specific provisions of the rule, and I think and how the rule-making process has gone. This has been, and again, I'm not a D.C. lawyer, but from what I read and from what I'm hearing, the amount of force, I'll say, that has been used from the White House to push this rule through has been almost unprecedented, and I think that makes a lot of people uncomfortable. So, get out and vote Republican, and we'll see where we get.
Okay. I think we'll take one more, and basically the question, I think you may have touched on this already, but registered reps, RIAs, IARs already have a fiduciary responsibility with their clients, so how will this new rule affect these security professionals?
So, again, they're in position A as far as complying because, when I talk about the burden, I'm really talking about, somebody moving from the suitability standard to a fiduciary standard. So from a how I need to approach my client and how I need to make a recommendation, it changes very little unless you're dealing with registered products or with VAs, because then you're under the BICE if you want to take a commission. There's no way out of that. So the only way is you either you and your BD deal with all of those BICE requirements, or you shift even your VA business away from a commission to pure trail AUM, and it's really a fee on AUM, even though it looks exactly like a trail, because you cannot take a commission unless you're dealing with all the other stuff that comes under that BICE.
Perfect. All right. So, ladies and gentlemen, David, we appreciate your time. As always, amazing. I saw David in New York talk about this as well a couple of months ago, and once again, thank you very much. Your knowledge and your attention to this matter is exceptional. We love and appreciate having you available to us. If anyone has any additional questions, feel free to email us at our info at KesslerFinancial.com. Our number is also 800-699-0299. Any of the wholesalers here will be able to field those questions for you. We appreciate your time. Just stay focused. It affects everybody the same. We're all in the same boat, so we just need to keep marching forward. Look at the industry and life through the windshield and not the rearview mirror. All right, you guys have a great day, and once again, thank you for your time. Take care.
Thanks, guys.
Yep.